Hi, everyone. Thank you so much for joining our quarterly compliance webinar, providing insights to employers on the latest in industry legislation, regulatory updates, and noteworthy compliance topics. This webinar is brought to you by Orange Tree Employment Screening and will be hosted by Heidi Seaton, Orange Tree's VP of Legal and Compliance. Heidi has been in the background screening industry for 18 years and has been at Orange Tree for 10 years. Before Heidi's presentation, Jeff Ernst, Orange Tree's VP of Sales and Marketing, will provide an update on what's new at Orange Tree and what we're hearing from our talent acquisition and HR community. If you have any questions, you can always email compliance@otes.com or text them over to Jeff at 952-237-7471. You can also ask questions during the webinar through the chat box. Just a reminder, the presentation and recording of the webinar will be available afterwards as well. Thank you all for joining us.
Thank you very much, Suzanne, and welcome everyone. Good day. Hope you're having a terrific day today. We're excited to have you with us for a quarterly compliance update led by Orange Tree's Heidi Seaton. Before we get to the main presentation, I do have a couple of things to cover with you. Our clients today, the next chart, our clients today are more interested than ever in monitoring their employees throughout the tenure of their employment with the company. There are a variety of reasons for this, ranging from government legislation through brand image. I'm sure Heidi will touch on many of these reasons throughout her presentation. Because of this, Orange Tree has developed a continuous monitoring service for criminal offenses. Announced several months ago, interest and demand has been very high for this offering. If you haven't already spoken to us about this popular new offering, please reach out to your dedicated client success partner or sales executive today. Another exciting enhancement from Orange Tree is our drug test integration. Next slide. So let's take a look at the common problems with drug testing. Oftentimes you are placing an order for the background screen and drug test in two separate systems. When creating the drug test order, you are selecting a collection site that you aren't even sure will work for the candidate and manually sending an email to the candidate with the electronic chain of custody form. Then there is this black hole of communication. You don't know the status of the drug test or what stage it is in unless you go to the lab partner site or give Orange Tree a call. So what we have done is developed a front-end drug test integration. How does this work and how does it solve the problem? It's quite simple. We simply configure your background screening packages to include a drug test. Next chart, please. This creates a one-click ordering process for both the drug test and the background screen. Once the order is submitted, the integration sends the candidate an email and allows the candidate to select a collection site that is convenient to them. The candidate is able to electronically send themselves the chain of custody form through email and text. As the drug test progresses through the stages, you will see real-time status updates from registration to completion, all viewable within Orange Tree's mobile optimized Candidate Connect. Next slide. The table here shows you all of the annotations that are now visible in the Orange Tree Client Connect portal. You will be kept informed from beginning to end so you can retain control of your day while holding your candidates accountable to a timely completion of their drug test. Next slide. I'd like to share a quote from one of our client partners, Susan Cronin at Craig Therapeutics. Susan shared that they have received great time savings in both the initiation of the drug test order and turnaround time in receiving the results. I think that Susan says it best when she said that there's no comparison to the efficiencies gained by moving to Orange Tree. And finally, on my final slide here, my goal here is to remind you of our instant value drug test, like our continuous monitoring solution. And since we first started talking about this solution, client interest has been quite high. And the reasons are obvious. With 1 million more job openings and laborers in a growing economy, Companies need to fill seats as fast as they can so they can realize their profit objectives. The instant value drug solution allows candidates with a negative test to start within the hour, and the cost savings are also substantial, as you can see on the chart. So that concludes my remarks here today. It's my great pleasure to turn over today's presentation to Heidi Seaton, Orange Tree's Vice President of Compliance and Legal. Heidi, take it away.
Thank you, Jeff. Appreciate it. So Suzanne sort of took care of the intro, so I'm going to throw up the usual disclaimer. Most of you know me. My name's Heidi Seaton. I'm VP of Compliance and Legal here at Orange Tree. As Suzanne mentioned, I've been here for, it seems like a long time now. But I'm responsible for compliance here at Orange Tree, and I also spend a lot of time trying to help our customers understand their own obligations as they relate to background screening. So sort of a dual role there. And hopefully, that'll make sense as we start to talk about some of our compliance topics today. So this sort of two main things we're going to dig in on are, what's happening at the state and local level, and then also what are the developments at the federal level. So state and local. We'll start with ban the box. Those of you who have been to my sessions before, we usually do spend some time on this. We are still seeing a fair amount of action around ban the box at the state level, and then also, as you can see with this first slide on the topic, at the city and county level as well. Just remember, or for those of you who haven't attended with me before, ban the box is that effort that we're seeing it started grassroots, and it's definitely moved across the country over the last, let's say, 10 years. The idea being to remove the question about an applicant's criminal history from the application process. And as it's evolved, statutes and regulations have actually pushed when you can ask that question further and further down towards the end of the hiring and consideration process. So Westchester is a good example. This may have mentioned it on the last quarter's session, but it did become effective just earlier this month, so I thought I'd bring it up one more time. This county regulation says that unless an employer is required or permitted by some other law, that employer can't make inquiries into the criminal history during the employment application process. So you've got to wait until later in your process if you're going to be asking the candidate specifically about their criminal history. And then if you do take into consideration the applicant's criminal history, it references you back to the established New York state law. So that's the Article 23A requirements regarding doing an individualized assessment and following an adverse action process. So like other counties and cities in New York, as they've enacted this sort of legislation, they sort of point employers back to the Article 23A individualized assessment and adverse action process. But as it relates to when in the application process or when in the background screening process the employer can start to make inquiries into a criminal history, that has certainly varied from one county and city to the next, even in New York. The other big one, again, this passed a couple quarters ago actually, but became effective also here in March. That's in New Orleans, Louisiana. This regulation actually affects only city employers or city employees and city contractors. And so it doesn't, and it's not intended to have an effect on private employers in New Orleans. But it does, again, prohibit asking about criminal history on the initial employment application. The rest of these are areas where we're just seeing activity at the state legislator level. So either state legislator or local city councils, that sort of county commissions are introducing, or there's some pending legislation. So Omaha, Nebraska has a bill that's pending that would allow an employer to ask about criminal history on the initial application, but then the employer would have to give the candidate an opportunity to explain the record and detail any rehabilitation that they have undertaken since the record happened. So again, just to clarify, that's just pending, has not been passed. Also tracking state legislation, pending legislation in Kansas. So this is at the state level. It's intended to affect state employment, so not private employers. And it also would prohibit the state employer from asking about criminal history on the initial application. Maryland also looks like they're trying to push through some legislation. That one is intended to affect both public and private employers, and it would prohibit questions about criminal history on the initial application, but then would allow those sorts of questions in the first interview, but then not allow an actual background check until a conditional offer process. And as most of these do, most of these statutes or regulations include exceptions, and the very common exception is for law enforcement positions. New Mexico also looking at additional ban-the-box legislation. So they already have ban-the-box legislation dating from 2010 that impacts public or state employment. This bill targets private employers and, again, prohibits questions about criminal history on the initial application, but it does allow explicitly, as drafted so far, an advertisement that the employer can advertise that they conduct a background check and that a conviction could disqualify them. So interesting little twist there in New Mexico. And then in Virginia, again, pending state legislation, this bill was passed by the Senate, so could happen, intended to affect state employees, so not private employers, prohibits asking about the question, the criminal history question on the initial application, and includes that law enforcement exception. A newer trend, but we've talked about it before, this is another state and local effort to limit employers' inquiries into past salary history in the hiring process. This is also an anti-discrimination effort. We see Atlanta, Georgia passed a salary history ban that applies to city employees and applicants, and then Suffolk County, New York, applies to any employer in the county, says the employer can't make an inquiry at any point, can't even do a public search for that information, and that's effective here in the middle of 2019. For those of you first time hearing about these salary ban statutes and regulations, to my knowledge, we've got 13 states that have passed some sort of statute, and then 11 local laws on the books. And so it does vary from state and county and city to state and county and city about, who it applies to, just like ban the box. Sometimes they're attempting to regulate the behavior of just public employment. Sometimes they are attempting to regulate the behavior of private employers as well. And then there is still some controversy about whether the statute is effective in a couple of jurisdictions. There's been some litigation to try to stop them. But in general, we're seeing this happening fairly regularly and honestly without a ton of controversy. In most cases, it seems to happen fairly quickly, and there's not been a ton of pushback, at least that I've been hearing about from employers. So be aware of those. Moving on to EVerify. I know, EVerify, right? We really haven't talked about EVerify, especially at the state level, in quite some time, because we haven't had new states pass any EVerify legislation for a few years. So this effort here in Iowa, it is still pending legislation. It has advanced through Senate committee, sparked by the really tragic kidnapping murder of Molly Tibbetts. Her alleged killer was found to be in the country illegally. He had presented out-of-state identification and worked at a local farm under a false name. So this statute's been introduced. It's pretty tough on employers. It's intended to apply to all employers, public and private. It includes some significant results if an employer is found in violation. So there's talk of prosecution, certainly a suspension, revocation of business license for first and second offenses. At least that's just how the statute is written or drafted right now. All of that could change. Not sure if it'll pass in its current state, but there does appear to be some momentum in that state for this sort of law at this time. It is interesting, right? Given he was allegedly using someone else's legitimate identity, there's no saying whether he would have actually been flagged by EVerify if the employer had used it. So very interesting things going on in Iowa around EVerify. We'll watch that one. Moving on to drug testing. We won't spend too much time on this since it was the entire topic of last month's webinar. Thank you, Nina French from Current Consulting. Just a few developments that we're tracking. New York City, New York has pending regulation. They've introduced a bill to ban pre-employment drug testing that includes marijuana. So a panel restriction coming out of New York City. Again, just pending at this point. And then on the recreational marijuana side, I know we covered a fair amount again, like I said last month, but just New Jersey has pending legislation introduced that would legalize recreational marijuana. So as we see things move through, following that same pattern of usually the states are enacting legislation around medical marijuana first, and then usually in the next few years after that, there's a move towards recreational marijuana as well. A related trend, sort of unexpected, but we are seeing a few of these pop up, and I actually expect to see more. As states are legalizing, especially recreational marijuana, they're just decriminalizing marijuana offenses, some of them, right? And so we're seeing this trend of jurisdictions proactively going out and expunging or sealing those decriminalized cases. In San Francisco, the DA had identified over 9,000 marijuana convictions that were decriminalized, created an automated way to move that expungement process through, or he created an automated way to identify the cases and then moved those cases through the courts. So interesting to see that happening from the DA. But sort of similarly in Denver, the mayor, the DA, the city attorney collaborated on a program that they called Turn Over a New Leaf. And they also identified, or basically they put a process in place for an individual with one of these decriminalized records to submit an online application or show up at a clinic, get that request to have the document or the record sealed in front of a judge, and judges are ruling on these requests sometimes without even bothering with the hearing. So it's pretty pro forma. Interesting. In the case of Denver, their program, the records are being sealed, not expunged. In San Francisco, they're actually expunging those records. We expect to see more of these as states, counties, cities decriminalize and start to, I should say, states are decriminalizing the marijuana drug offenses. Moving on to drug testing case law, we've had a few interesting ones, actually. In Whitmire versus Walmart, this first one, a Walmart employee obtained an Arizona medical marijuana card and had been using the drug as a sleep aid and a treatment for chronic pain. In 2016, she injured her wrist on the job. She filed an incident report. So this is a post-accident, ends up being a post-accident situation. She filed the incident report in the same day, but didn't seek medical attention. 2 days later, she notified her employer that she had pain. They sent her to urgent care and ordered a post-accident drug test. The test was positive for marijuana, and the employer concluded that upon reasonable belief, her positive test had result for marijuana indicated she was impaired by marijuana during her shift that same day. She was suspended for the test and eventually fired. She filed suit and alleged she was wrongfully terminated and discriminated against in violation of a couple of state laws. And a federal district court judge granted summary judgment, in part for her, which means the case was allowed to move on. They said, summary judgment on the question of Walmart's liability for discrimination under the Arizona Medical Marijuana Act. They said, quote, without any evidence that plaintiff used, possessed, or was impaired by marijuana at work, it's clear that the defendant discriminated against plaintiff in violation of the medical marijuana statute by suspending and then terminating her solely based on her positive drug screen. So that's a case where medical marijuana was authorized by the state statute. The individual had a legitimate marijuana card. The employer was doing a post-accident reasonable suspicion test, but the testing was done sometime after the accident. And so the court said there wasn't any evidence that at the time of the accident that the plaintiff had used, possessed, or was impaired by marijuana. So problematic for post-accident testing in Arizona, although we know, right, because if we're doing post-accident testing, we know that we should be looking for more than just a positive drug test, right? We should be recording what actually went on with that accident, right? Like, did the employee appear to be intoxicated? You know, looking at the activities of the employee and not just relying on that drug test. Also interesting, Nossinger. This is the District Court of Connecticut, and they granted summary judgment to the plaintiff employee of the Rehabilitation Center, SSC. In this case, the plaintiff filed a discrimination claim under the Connecticut Palliative Use of Marijuana Act. That act makes it illegal for an employer to refuse to hire a person or discharge, penalize, or threaten an employee solely on the basis of such person's or employee's status as a qualifying patient or primary caregiver. The court had previously held, by the way, in another case, that PUMA, which I love that acronym, isn't preempted by the Federal Controlled Substance Act, by the ADA, the Federal ADA, or the Food, Drug, and Cosmetic Act at the time. So the previous decision was interesting because it was the first federal decision to hold that the Controlled Substances Act preempted a state law, state medical marijuana law. That was a departure from other decisions in New Mexico. In this recent decision in Nossinger, the district court again considered whether PUMA was preempted by federal law, and in ruling for the plaintiff, the employee, the court rejected SSC's argument that its practices, because they are required by federal law or required to obtain federal funding, fall within exception of PUMA's anti-discrimination provision. SSC argued that in order to comply with the Federal Drug-Free Workplace Act, which requires federal contractors to make a good faith effort to maintain a drug-free workplace, it could not hire the plaintiff because of her failed pre-employment drug test. The court said not persuaded. They said the DFWA, that Federal Drug-Free Workplace, doesn't require drug testing. Isn't that an interesting interpretation? So, Drug-Free Workplace Act requires federal contractors to make a good faith effort to maintain a drug-free workplace. This court said that does not mean that it requires drug testing. Nor does it prohibit federal contractors from employing people who use illegal drugs outside the workplace. So that's, of course, always the other issue with these cases is where or when are the drugs being used. The court noted that simply because SSC's zero tolerance policy went beyond the requirements of DFWA doesn't mean that hiring the plaintiff would violate the act. They also rejected SSC's argument that the Federal False Claims Act prohibits employers from hiring marijuana users because doing so would amount to defrauding the federal government. They said no. Federal law prohibits employers from hiring individuals who use medical, because no federal law prohibits employers from hiring individuals who use medical marijuana outside of work. Employers do not defraud the government by hiring those individuals. So, very interesting arguments. And then they also made a statement about PUMA. They said they rejected the theory that that state medical marijuana law only prohibits discrimination on the basis of one's registered status and not the actual use of marijuana. They said such a holding would undermine really the purpose for which the employee obtains the status. So employer did not prevail there. And then finally, a third case. This one's Montana law, Ninth Circuit decision, Carlson v. Charter Communications. Here, the Ninth Circuit, as you know, if you've spent any time with me on these sessions, has a reputation as employee friendly, right? But here in Carlson, the Ninth Circuit refused to revive a former employee's lawsuit against his employer, Charter. He had alleged that he was wrongfully terminated due to his legal use of medical marijuana. So the case involves a marijuana statute, the Montana Marijuana Act. It allows patients with state-issued medical marijuana program cards to have certain amounts of marijuana in their possession. The employee in this case was fired for his legal marijuana use outside of work, which was a violation of the company's employment policies. He sued for wrongful termination and discrimination. The district court dismissed the case and said, yep, we agree with you, the employer. The Ninth Circuit affirmed and dismissed, again, based on the fact that marijuana is still illegal under federal law. Thus, it was not unlawful for an employer to have a policy prohibiting its use and to terminate an employee for violating the policy. The court said, since the Montana Marijuana Act contains no provisions prohibiting employers from forbidding their workers to use marijuana, nor does it allow employees to bring wrongful termination suits, the statute doesn't prohibit the action taken by the employer here. So, again, an important difference here between Montana law and Connecticut law. The other caveat here, in this case, and Nofsinger, is that the employer is a federal contractor and thus was required to comply with the requirements of the Drug-Free Workplace Act. So, interestingly, in this case, the court did not hold that the Drug-Free Workplace Act preempts state law. It simply held that the state law itself does not preclude a federal contractor from complying with all the requirements of the DFWA, such as prohibiting the possession or use of marijuana in the workplace. This court found no conflict between the two laws. So compare this case with the last one. In Nofsinger, the court rejected a federal contractor's argument that despite Connecticut's law, allowing medical marijuana use that the DFWA prohibited from hiring applicants who tested positive on a pre-employment drug test. That court found no preemption of state law, noting that DFWA does not require a drug test or prohibit the employment of individuals using illegal drugs outside the workplace. In addition, the Connecticut statute, unlike this one in Montana, does in fact provide a private right of action to a person who suffers an adverse employment decision. So very interesting times, people, especially for a multi-state employer. In states where marijuana use is permitted, the way those laws interact with employment can really just vary quite widely as we compare these two cases. A couple more examples. In Pennsylvania, for example, employers can't discriminate against certified medical marijuana users, but the state's law doesn't address whether employers must accommodate the use of the drug. The state of Maine has a statute specifically prohibiting employers from refusing to employ or otherwise take adverse action against a person who uses marijuana outside of work, except where the employer is required to comply with federally mandated testing. That's DOT testing, by the way, different from DFWA compliance, clearly. Arizona, another state where their medical marijuana statute prohibits an employer from discriminating against a person in hiring, termination, or imposing any condition of the employment or otherwise penalizing a person based on a registered qualified patient's positive drug test, for marijuana, by the way, unless the patient used, possessed, or was impaired by marijuana on the premises of the place of employment or during the hours of employment. Potentially tough for an employer to prove. And then Massachusetts also has some case law. In Massachusetts in 2017, an employee who'd been fired for medical marijuana use was allowed to proceed with their lawsuit, alleging the decision violated the state's anti-discrimination law. In that case, that employee was fired after 1 day of work after failing a pre-employment but post-offer drug test. The employee made a request for accommodation for her Crohn's disease in that case. That would have allowed her to use the drug off-site and outside the work hours. The court ruled that employee's request wasn't necessarily unreasonable, saying a jury should decide. So, again, problematic for an employer if a court's going to say cases like that have to be decided based on the individual facts and not just based on interpretation of the law. So, moving on to a few federal topics. Looks like we're about halfway done here. Let's start with litigation, and let's start with the Fair Credit Reporting Act. This is a case Gilberg got a lot of press. In this case, the plaintiff had applied for a position with the employer. This was in California. As part of the process, she received, actually I don't even know if it's she or he, the plaintiff received a document called Disclosure Regarding Background Investigation in 8-point font, that the employer intended to order the background check and had space for her to provide her authorization. And the one-page disclosure included various statements about her legal rights, as well as certain state legal right disclosures. So used to see this fairly commonly where you would make the federal disclosure and then you'd make any state-specific disclosures also on the same page. Certainly that practice has gone out of favor. It's no longer best practice. But I think that's what happened here in this case, is that they probably just had an old version. The employer had originally successfully moved for summary judgment. They won. The case was dismissed. The applicant, or the named plaintiff, appealed, and the Ninth Circuit, again, reversed and reinstated the lawsuit. So they said they had a couple of issues, but it really did come down to that old issue. We've talked about this a couple of times before, that requirement for the FCRA disclosure part of the document to be a standalone document. And then a little less discussed was also the requirement for the disclosure to be conspicuous and clear, is also the requirement for the disclosure to be conspicuous and clear. They said here there was two issues. One, the FCRA disclosure was not standalone because it was combined with state-specific disclosures, other states. And they also said it wasn't clear. There was some grammar issues. They also said that including additional states' rights was more likely to confuse than to inform the consumer. And then there was also under California consumer law it also has a clear and conspicuous requirement, and so there is also a California state law issue there. So interesting case. Again, if you haven't looked at your disclosure and authorization forms for your background screening process, please do it now. On the Orange Tree side, if we're making disclosures on your behalf and getting authorization, we do have separate forms as our standards. So we've got the federal disclosure that happens, and then any state-specific disclosures happen on separate pages. We also no longer combine the disclosure and authorization together. So they're just so that nobody is tempted to add extraneous language to that disclosure. We keep them separate. So double check your forms if you're not using ours, or if you've made changes to our standard forms. It might be a good time to look at those again as well. In other FCRA developments, Pitre v. Walmart. This one, so we've talked about the Fair Credit Reporting Act, and the issue, one of the big issues for employers is how ripe it is for class action certification. So this case came up. It should sound a little bit familiar. This is out of California. And the claim here was that the employer added extraneous information to the background check disclosure notice issued to applicants. They said it violated the Fair Credit Reporting Act. Instead of providing a clear and concise disclosure about the background check in violation of the FCRA, it also claimed violation of the California Investigative Consumer Reporting Agencies Act. So again, it should sound familiar, right? The really stunning thing about this case was the class certification size. So the court certified that class with approximately 5 million people in it. Why is that stunning? Well, just remember, the FCRA provides for statutory fines, and when there's a negligent violation, the fines or the damages are the actual damages, right? Like what actual damage did the plaintiffs have? But when there's a willful violation found, the court can do actual damage or a dollar amount. So, and the dollar amount's not less than $100 and not more than $1,000 per violation. So if you do the math on 5 million times $1,000, much less, or even $100, you can see why that's sort of a stunning certification. By the way, that doesn't; those damages don't include any punitive damages for which there's no limit. So keeping an eye on that one to see where that goes. In other Fair Credit Reporting Act developments, so interesting, the court actually called this a novel theory of the Fair Credit Reporting Act application. So that always catches my eye. In this case, the issue was, this is coming out of the Seventh Circuit, it was actually an investigation. So it was like a employee misconduct investigation. It was conducted by a third party, happened to be a law firm, into misconduct. The plaintiffs argued under the FCRA that the FCRA was violated because they didn't receive a copy of the report. The court said no. They actually held that there was no standing. So that's actually, if you remember when we talk about Spokio in the last couple sessions, Spokio is the case that requires, in order to have standing under the Fair Credit Reporting Act, that the plaintiff has to plead a concrete or particularized harm. So in this case, they said no standing because they haven't pled what the harm was. And then they just sort of threw in as an aside, an outside investigation probably is not a consumer report under the FCRA. And a law firm in this case is probably not a consumer reporting agency. So I think great, actually, information for an employer to have. But you don't see this sort of topic coming up all that often, so super interesting. And then in Smith, for those of you that background screened independent contractors, an interesting case popped up in Iowa recently. This was in the Southern District of Iowa. Here, the plaintiff applied as an independent contractor and then was not hired as a result of an inaccurate felony conviction on the consumer report. They alleged that he didn't receive a copy of his consumer report before the defendant took an adverse action. Really interesting opinion there coming out of the Southern District Court of Iowa. In this case, the judge said, just based on a plain reading of the Fair Credit Reporting Act, the requirements around adverse action say the statute is limited to reports used for evaluating a consumer as an employee. So finding, they said that's unambiguous. They said the FCRA's requirement of pre-adverse action only applies when the applicant applies to be an employee. And so they decided in this case, the FCRA did not apply to independent contractors. But it sent it back, by the way, to the lower court to say, do some fact finding. Let's actually confirm whether or not, even though this is labeled as an independent contractor, whether or not they really were an independent contractor or if they were a direct employee. So a very common sense approach to reading the statute. Throw that up against, by the way, the Federal Trade Commission's 2011 staff report. They called it 40 years of experience with the Fair Credit Reporting Act. It's that 40 years document from the FTC has sort of become a little bit of the Bible, right? They said that employment purposes should be interpreted liberally, that it could apply to situations where an entity uses an individual who's not technically employees to perform duties, including contractors, agents, and volunteers, so long as the relationship is substantially analogous to employment. So much broader advice coming from the Federal Trade Commission. Their interpretation was based on a 1975 case, which noted that, too, the FCRA could apply to independent contractors under some circumstances because courts are not constrained to limit application of common law concepts to master and servant. So going back, a little bit of a legal concept about, that employer, master, servant test, which can vary from jurisdiction to jurisdiction, but sort of a surprising ruling. What employers really should be taking away from this, I think, is just remembering. So this is the Southern District of Iowa. It's one case. I would not take this one case as a reversal for all of you employers who have independent contractors and you are screening and you're assuming the Fair Credit Reporting Act applies. But certainly one to watch, and I hope it becomes a trend, but I do not hold my breath. Moving on to legislation at the federal level. So again, I'm talking mostly here about pending legislation, nothing big enacted, but there is a fair chance legislation bill that's been introduced, companion bill, so in the House and the Senate. It is still pending, but the idea here being, so remember back when we were talking about state law, there's a hodgepodge now, right, of all these states and counties that have different rules about when the employer can or cannot make inquiries into the consumer or applicant's criminal history. This fair chance legislation is really just intended to normalize that across the country, right? So the specific language in this legislation postpones asking the question until the conditional offer. It is only applicable, as written right now, to the federal government and federal contracts, and has the normal exceptions. I think if we analyze momentum at the federal level with legislation right now, I don't see it passing. I just think there's not enough momentum to get it pushed through the process. But we will keep watching this one. Interesting. I think it could actually be a significant boon for employers. I think being able to predict when you can ask the question in every circumstance instead of having to take it on a case-by-case basis based on what state you're in or what state your employee is in, I think it would be a significant help to employers. But I just don't think that there's enough push behind it for it to actually happen this year. Another one that super interesting, EVerify introduced. So this is a Accountability Through Electronic Verification Act. It was introduced by Chuck Grassley. Again, the Iowa connection, linking that back to what we saw happening at the state legislation level. House has introduced a companion bill, and again, pending. Gosh, I don't think I put that on the slide. I'll be sure to do that before we send it out. This is not passed. This is just pending introduced legislation. As written, it would require all employers in the U.S. to begin using EVerify for all employees within 1 year. Federal agencies would have to use it immediately, and critical employers, who would be determined by, I can't remember which federal agency, but would have 30 days to start to use EVerify. Trying to imagine the impact that would have on the EVerify system. I'm a little skeptical, but we'll see if that happens. The other parts of the statute as authored in the introduced bill and the Senate bill, it would permanently reauthorize the EVerify program. That program's been reauthorized periodically. It would increase penalties for employers who illegally hire or retain unauthorized workers, but also reduce liabilities for employers that participate in EVerify. So we'll watch that one. Again, I don't think there's enough momentum. I feel that way, honestly, about most federal level lawmaking right now, but we'll keep an eye on it. And then around privacy legislation. So California enactment of its own privacy legislation in June of last year really increased momentum for enactment of a general federal privacy law. Also, by the way, spurred state legislatures to consider privacy bills as well. I didn't cover that on the state and local. Maybe next quarter I will. Additionally, sort of widely publicized issues with large technology and social media firms, data handling practices. Also throw in the European Union's General Data Protection Regulation that came into force in 2018. All of those adding visibility as well as urgency to an effort to create a privacy law at the federal level. Many bills have been introduced. There have been hearings, committee hearings. Again, in my opinion, I don't see that there's enough consensus on the content of any particular bill for that to move its way through the process, but we'll keep an eye on it. You guys may know Orange Tree is a member of the National Association of Professional Background Screeners, and NAPBS, as we like to call them, has a lobbying arm. So at our mid-year conference this year, we're in DC, and a group of us will be going up to the Hill to lobby. And the privacy legislation is one of the topics that we're lobbying for. Whichever bill becomes the front runner, we are urging our legislators to try to harmonize the data privacy laws with the Fair Credit Reporting Act. So we support a federal approach as opposed to a state-by-state implementation. We're asking them to establish a clear regulatory framework that protects consumers and promotes private sector innovation. And then also just reminding them of what a burden the state-by-state regulatory environment related to breach already is, and throwing privacy requirements on top of that would be even more burdensome, especially for employers and potentially consumers as well. And then part of that effort, that lobbying effort, is we're encouraging Congress to direct the Federal Trade Commission to adopt a universal disclosure and consent process to reduce paperwork and confusion for consumers. So again, that Fair Credit Reporting Act, the FCRA, litigation that I was talking about, so often that's all about making disclosures, getting authorization that's required by law, but no regulatory agency has ever come out with a, hey, employer, if you put this language on your disclosure, you will meet the requirement of this law. So trying to get that sort of regulator-created framework or process into the FCRA, perhaps as part of this privacy legislation, so that it's clear to everyone exactly how to get that done. And I think that brings me to the end of my slides. We've got some links on this page. My contact information is there. I see I misspelled my last name. I'll fix that. There's no E at the end of Seaton. Feel free to send me an email. And then Jeff provides his email address. You can also text him. I can take questions here at the end if there are any, but just know I honestly do a little better if I can think about it. So feel free to send me an email if you would rather do that than have me try to answer a question on the fly. Suzanne, any questions that have come over?
Yep, I see one there, and it's just a question on, are there any updates to adverse action that we should know about?
Updates to adverse action. I would say probably nothing happening at the federal level that I can think of. Do think about all of the ban the box state and local legislation. As I sort of explained ban the box, it's about taking the question about criminal history information off of the employment application, moving it later into the process. But as those laws have evolved, they've moved outside of it, so it's not just the pre-application or pre-employment process or the pre-background screening process, but they also now start to regulate what the employer has to do if they're going to make a negative hiring decision based on the criminal history information. So think about specifically, I think I mentioned it last quarter, but the San Francisco Fair Chance Act, they actually have a poster that employers are supposed to be posting, and they're supposed to provide that notice about consumers' rights. It's a special form. So yes, I would say there's some activity around adverse action, but it tends to be jurisdiction, state, local, county, or city specific.
Okay, perfect. I'm not seeing any other questions, Heidi. Thank you so much. Thank you to Jeff. That was all very interesting, very relevant, very helpful. If you have any questions for Heidi, she will be providing her email and Jeff's email and mobile number there as well. Just a note that our next webinar will be on April 24th, same time, noon Central, and it will be given by attorney Scott Paler. The topic will be a deeper dive into the Ninth Circuit Court's ruling and then updates on compliance in California. And then just to note that the recording of the webinar and copy of the slides from the presentation will be sent out after the fact. So thank you all for your attendance, and please be in touch if you have any questions.